law nerds. Welcome to a special live reaction episode of Boom Lawyered, a Rewire News Group podcast hosted by the legal journalism team that is stunned again. What's happening? I don't know. My name's Imani Gandy. I'm editor at large at Rewire News Group.
And I'm Jess Pieklo, Rewire News Group's executive editor. Rewire News Group is the one and only home for expert repro journalism that inspires you to celebrate ICWA surviving, because really, we didn't see that one coming. And the Boom Lawyered podcast is part of that mission. So a big thanks to our subscribers, a welcome to our new listeners and viewers and live stream participants. Hello.
Jess, we are
Imani.
2 for 2 when it comes to the cases that we've been watching and that we said all season was going to be weaponized by the Fed Sox 6. 2 for 2. Last week, Robert surprised the hell out of us by saving the Voting Rights Act. And then today, Amy Coney Barrett surprised the hell out of us by saving the Indian Child Welfare Act. So here's what she said. My Amy Coney Barrett, it's not nearly as good as yours, but I'm working on it.
It's a pretty solid Amy Coney Barrett.
Thank you. Thank you. I've been working on it. So here's what she said. Ultimately, the bottom line is that we reject all of petitioners' challenges to the statute.
What?
Exactly.
Really? I had to read that like 3 times when I saw that.
Yeah, I mean, I honestly read that. I was like, what is going on? And then you were like, did we win? Like, very confused.
Truly.
This was the case I was most worried about, right? Because I think it would have had the most far-reaching consequences when it comes to the destruction of tribal sovereignty and the advancement of white supremacy and the continuation of this cultural genocide that began when settlers came to this country and began scooping up all of the lands that didn't belong to them, scooping them up for themselves.
I mean, basically, yeah. So let's get into it. Let's hit the main points first, and then we can really sort of break apart this opinion. Okay, by a 7-2 vote, also a surprise, right? The court upheld the Indian Child Welfare Act and rejected all of the petitioners' claims, either on the merits or because of standing. And we're going to talk about that because some of that standing stuff is a little slippery. The 2 dissenters, would it surprise you to know, were Justices Alito and Thomas. I mean,
those 2 dissent from common sense and reality. Like, honestly, I'm done. I am done with those 2.
On social media, Susan Rinkin said Jezebel called them the Disgusting Brothers as a nod to Succession.
The Disgusting Brothers. Yeah, really, they are.
And like, truly. All right. So here's the background. ICWA had been challenged by 7 individual plaintiffs in 3 states, claiming basically that it was unconstitutionally racist because it gave preference to tribal families and relationships in foster care and adoption proceedings. Right. So that was the nut of the argument. Petitioners made 3 claims. 1, that Congress exceeded its authority when it passed ICWA, so beyond the scope of what Congress can do. 2, that the law commandeers state agencies and directs them to enforce federal regulatory programs. This is a 10th Amendment argument, basically, that Congress is coming in and stepping into the state's business. And number 3, that the law violates the Equal Protection Clause because it places Indigenous children based on their race.
And on the 3rd point, I mean, the point that was really most egregious, like some of the most egregious arguments relate to that 3rd point, relate to that claim that that it violates the Equal Protection Clause because it places Indigenous. Essentially, the way they phrase it is that it puts white people last in line when it comes to the placement of Native American children, and if you just imagine like the privilege that it takes to even think that way, like that's the way the Brakeens and the Cliffords and some of these other individual plaintiffs think. They think that they were placed last in line, and that's not fair. The Equal Protection Clause says you can't put white people last in line for anything, even if it's adopting Indigenous kids and trying to maintain families and tribes. But the court didn't hit that point.
Yeah.
Not on the merits anyway, right? The court said that petitioners didn't have standing. So the court punted on that issue, but I'm going to go into detail about that a little bit later. So let's backtrack. Let's just talk about Barrett writing this opinion. Why did Barrett write this opinion?
I mean, right when I saw that she had the ICWA opinion at first, I had chills because, I mean, you see that and you think this can't be good, right? And then, I mean, I don't know. And we've been talking about why did Barrett write this opinion as opposed to like Gorsuch, who, tribal law is his jam, right? I don't know.
Yeah, I mean, first of all, something about Amy Coney Barrett having adopted Black children and then writing about the adoption of this transracial adoption issue when it comes to Native children. I don't know how it makes me feel, but it makes me feel some kind of way. That's all I'm going to say about that. But then also, like your bearded paramour, Neil Gorsuch.
The pandemic was a rough time for all of us, and that beard suits him. We will say no more about it, but I'm just saying we did what we had to do to get through lockdown.
We did. But, it's Gorsuch's concurrence that really lays out why it is ICWA was such a necessary statute, right? He goes into the history of the boarding schools and how kids were literally abducted by government agents and placed into boarding schools where they were sometimes starved to death, beaten. Yep. They have higher rates of suicide and drug addiction because they were literally taken from their homes and stripped of their culture. They had their hair cut, which is a big thing in Native American culture. They were placed with other children from different tribes. So there was no way that that children could maintain their language skills, their communication skills, right? Their heritage communication skills. And that's what that's literally what white folks did with enslaved Africans, right? Yeah. They brought us here and they cut our hair and they made it so that we couldn't speak our native languages. And that led to some really interesting things like Black people making maps in their cornrows and their head and their hair and everything. Anyway, that's a completely different topic for another time. But I think that was going to say, I think that Gorsuch's opinion, which reads like a majority opinion, wasn't the majority opinion because I don't think the other conservatives on the court wanted to sign on to all of the horrible shit that Gorsuch was saying this country did and continues to do to Native American people. So that's why I think, because his opinion really, it's beautifully written. It lays out all the issues, and it should have been the majority opinion, not this boring ass shit that Amy Coney Barrett.
Right. Wrote. That's what I was going to say. Amy Coney Barrett, I'm just going to say it. Look, she's boring. She is dull. This opinion is a snooze fest. And I cynically think one of the reasons why they gave it to her, you said, it's icky. Something about it just makes you feel icky given the fact that she's an adoptive mother. I think the conservatives see her as like the court's mom, right? And so this is a case that involves kids and adoption. So give it to the mom on the court, right? Even though there are other mothers on the court, right?
Right.
At any rate, I think that's part of it because when you do contrast them, like Gorsuch's concurrence is gorgeous in its language and its writing, and it's not just because he looked good in the beard. It's actually very, very good. But, they do complement each other. Hers reads like a manual.
Yeah.
Right?
It's just like, here's the law, straight down the middle, nothing, no emotion either way. And Gorsuch is like, we done fucked up when it comes to Native Americans over and over and over. Native Americans come to our court with their bowed heads and they can't get any justice. And do you know what we've done to Native American kids? This is what we did. It really was just like very extensive. And I was like, all right, buddy.
I'm surprised he didn't announce the concurring opinion as coming from like Potawatomi lands or something, right?
Seriously. Exactly. So, but let's get into it, right?
Oh, yeah.
On the first point that you mentioned, right? Whether or not Congress exceeded its authority when it passed ICWA. No, they didn't.
No,
they didn't.
Come on, guys.
Honestly. I mean, Congress has plenary power to legislate with respect to Indian tribes, right? Now, plenary power means like a whole lot of power. It doesn't mean absolute power. It doesn't mean unbounded power, but it's a shit ton of power that they have, and they are
legal
allowed
term of art.
Legal term of art, and they're allowed to exercise it. That power stems from the Indian Commerce Clause, which specifically authorizes Congress to regulate commerce with the Indian tribes. But Imani, kids aren't commerce. That's really creepy to refer to kids as commerce. Well, no. Kids are not like a unit of commerce, but when it comes to Native American tribes and when it comes to maintaining their culture, they are a resource. And Native American people talk about their children as a resource, right? And there's a reason why this country was snatching them up and separating them. It's because if you don't have the resource of children, then eventually you won't have a tribe because the tribe will all die out and all of the children will have been sprinkled about in white Christian families across Texas or Indiana or Louisiana, right? So that's number one. And also, the court has recognized over and over and over Congress's power to displace the jurisdiction of state courts in adoption proceedings involving Indigenous kids. Indigenous kids are just separate. right? Like they are separate. And that's how it is. That's how it's been for 40 years since 1978. That's how it's going to be.
Done there, right? Yeah. I mean, the bottom line is that the Burkines argued that ICWA treads on state authority over family law. Like that was the nugget of their argument. But conflicting state family law is preempted. That is a basic principle of constitutional law, right? Like Supremacy Clause 101, Burkines.
Easy. And the Burkines also argued that the Commerce Clause provides authority over resources, but not individuals, right? They tried to make this claim that it was creepy to call kids units of commerce. But, as I said, these children are resources, right? They're these tribes' natural resources. It's how they are going to continue keeping the tribe going from generation to generation. Also, I just want to point out, how shady the Burkines are just generally, because, and this is something that I learned recently after I relearned it, I should say, after I re-listened to Rebecca Nagel's podcast, This Land, which if you haven't listened to, honestly, the investigative journalism that she did in that podcast and the way in which she described everything that happened in the court proceedings, it is absolutely true that if you listen to that podcast, you will know more about the Burkines and what went on with this case than the court deciding it did.
Mm-hmm.
Right? Because the lower court denied discovery. So it was just like whatever Chad and Julie Burkine said went. Oh, it's very frustrating. Very frustrating.
I mean, I think, this is why Gorsuch's concurrence opinion is, again, so important, right? Because we have the Burkines making these arguments, and Amy Coney Barrett gives us this very middling, nope, we just don't agree with it. The law doesn't say that. And Gorsuch gets into the history, which is important because, hey, the government spent decades, right, trying to eliminate tribes by abducting and adopting out their kids. Mm-hmm. There's no way that the court could, there is a way that the court could have reached this case without discussing that history. And I think that's what Alito and Thomas were driving towards. But Gorsuch made sure that didn't happen. And it feels a little uncomfortable to give the man that much credit. But hey,
he's always been good on issues with Native American.
This is his space. This is his lane.
So absolutely.
All right. The other argument that the court rejected outright was this anti-commandeering claim. And this is a little weedy, but it's also pretty straightforward at the same time. Okay, so the petitioners claim that the law directs state agencies to provide all of these extensive services to the parents of Indian children, even though the 10th Amendment prevents Congress from commandeering states to enforce federal regulatory programs. So basically the argument is, hey, ICWA unconstitutionally tells state foster care and adoption agencies how they have to proceed, right? State child protective services proceedings, how they have to go. And we just don't do that.
Yeah.
But the 10th Amendment doesn't apply if the law applies to any party, not just state agencies. So the 10th Amendment is really designed to balance the power of the federal government and the state government and how those two governments interact with individuals. If other individuals are involved in that, it no longer becomes a 10th Amendment question.
Yeah. Pretty simple.
And it's been a minute since I was considering 10th Amendment law, but here we are, right? So a demand that either public or private actors can satisfy something is unlikely to get into sovereign power. So it's not a 10th Amendment issue here. Right. And on that part of the opinion, I thought Amy Coney Barrett was actually pretty good. It was useful to have dry, boring prose.
Very dry, very boring.
An adjective is okay.
Yes, seriously, just some emotion would be useful.
A little flourish is okay.
It is okay. And then that third question, right? We're gonna circle back. We put a pin in it before. Now we're circling back to the equal protection question, right? And
this is the big one.
This is the big one. This is the one where white folks were saying it's reverse racist to place Indigenous kids with Indigenous families first, right? We should be at the front of the line, or we should at least be at the same level. Which, okay, whatever. But I have things to say, but I'm not going to say them now. But the issue here, and Amy Coney Barrett said, there's no equal protection analysis. They literally punted on that issue because the petitioners, neither the individual petitioners nor the state petitioners had standing to raise these claims, right? The individual petitioners were arguing I'm sorry. She said that the individual petitioners did not have standing because there was no remedy that the court could offer those individuals that would make them whole. Right? Because
there's nothing the court could do to fix what they were complaining about.
Right. Because who did these plaintiffs sue? They sued the Department of the Interior, right? They ended up suing like 5 different Native American tribes. But those tribes and the federal government don't actually implement ICWA, right? They're not responsible for how children get placed. They're responsible for making the rules. The federal government made this rule, and now the states have to follow this rule. But it's the state agencies that implement ICWA, and then it's the state courts that place the children pursuant to the implementation of ICWA by these state agencies. So essentially, they sued the wrong people. And with respect, and I just want to say the way that she words it, she's basically telling people, it seems like, here's how you can bring an equal protection clause a little bit later if you want to.
Yeah, absolutely. I mean, I think that that's really it. It's good that the court didn't touch the equal protection claim, I think. But this is, I feel like, one of those poison pills in a really good decision. This is the court giving an opportunity to conservatives to come back a second time. And we've seen conservatives on the court do this over and over and over and over again. This is normally Alito's trick, but I think it's sort of across the board here.
Absolutely. And then when it comes to the state petitioners, it was Texas and Indiana and Louisiana. And by the way, that's another thing that I learned from Rebecca Nagel is that those 3 states have less than 1% of the Native American population in this country. The 28 states that opposed those 3 states, they contain something like 95% of the Native American population, right? And they were opposed to any destruction of ICWA. So I think that shows you, I mean, you've called this challenge to ICWA cooked up. That shows you how cooked up it is that these states don't even have any Native American people. So what are you complaining about, right? Go touch some grass, for crying out loud. But then with respect to those 3 states, Barrett said that they don't have standing because you can't raise equal protection claims on behalf of your citizens. Texas and Louisiana and Indiana were saying that the equal protection clause was violated because they promised their citizens to place children in foster care using a colorblind methodology.
Right. And this is their reverse racism claim.
And that's not a claim. Like what redress do you expect for that claim? Just stop it, honestly.
Stop it. Honestly, is the best response.
Just knock it off.
And so we have that very weird Kavanaugh concurrence, right? Justice
Miller High Life.
Miller High Life. Justice Kavanaugh filed a functionally 1-paragraph concurrence that was like, yep, everything that broad says. However, I would also reach the equal protection claim because I think it's important and I think the court should. And that is alarming because when you read Kavanaugh's concurrence, that signal that, hey, we think this is an important issue, along with the roadmap that Justice Barrett lays out, basically saying, oops, you guys got it wrong. Like, go back and do your homework over again, and we'll give you the higher grade this time around. Yeah. It really, I don't know, seems bad. Seems super shady.
Can you get the fuck out of here with your 1 paragraph? I don't know. There's this other case. First of all, the other case that he cites is a case called Palmer v. Sadati. That was a case involving, I think they were trying to place it was a custody battle. And I believe one of the woman was married to a black man. And so they didn't want to place the child with the black guy because he was black. Like, it was something really basic about like, oh, you're black, we're not going to place this child with you. It's not this entire statutory framework that Congress enacted in order to make up for the cultural genocide that this country was engaged in. So no, Justice Kavanaugh, Palmer v. Sadati does not apply. Just shut up.
You could have just said nothing.
Literally, sit there and eat your goddamn peas. I'm tired. I'm freaking tired. It's just such a gimme. Like, I know that Kavanaugh's clerks have read Palmer and they know that Palmer doesn't goddamn apply, right? Like, I'm sorry.
Come on, folks.
Come on, man. It's just the only reason he wrote that paragraph is because, oh God, the court did something they weren't supposed to do. You know, they upheld ICWA. So let me just make sure that you understand that when it comes to the part that you care about, the business about being reverse racist and white people being in the back of the line and how that's not fair, that's still a live controversy. Yeah. We'll see that coming back around.
And I mean, I mentioned this to you in one of our Slack chats today, but you know, first of all, I am not one to be known for having a lot of hope when it comes to the federal courts, particularly around reproductive rights, access, and justice issues. But I do wonder if there is a silver lining in the way that the court smacked the standing equal protection claims down, and what we're seeing the plaintiffs in the mifepristone lawsuit, the challenge to the FDA approval of mifepristone, what they're trying to pull, if maybe, I don't know, we can pull a glimmer of hope that when that case gets to the Supreme Court, Amy Coney Barrett will be as equally intolerant to the terrible bullshit standing arguments.
I mean, it also gives me hope about 303 Creative, right? Which is that case where the random lady who doesn't even make websites is asked the Supreme Court to tell her that she doesn't have to make websites for gay couples, even though not a single gay couple has asked her to make a website, and she doesn't even make it a goddamn website. She's asking for an advisory opinion. If the rhetoric and the jurisprudence that Amy Coney Barrett wrote about today applies generally, then that lady should get kicked out of court. Like,
yeah, we'll see.
Peace out, buddy.
We'll see. Stay tuned for that. And we will be doing a live stream when 303 Creatives comes down. You better believe it. We should probably talk about the dissenters, huh?
Do we have to? My God. Like, the dissenters are basically like, fuck them kids. We don't care. Like, I mean, whenever you see Thomas and Alito, like you see it's 7-2, you know who those two are going to be. And that's part of my problem with this court generally. It's like there's such hyper partisanship that it doesn't even, like, Thomas is trying to attack this from an originalist point of view or from a textualist point of view. Well, the framers didn't say that ICWA was a proper law, so therefore it's not. Like, unless the framers thought of every law that was ever going to be passed from then to the end of time, then according to Thomas, it doesn't matter. Like, it doesn't count. Unless it came out of one of the framers' mouths, it apparently does not count to Clarence Thomas.
Well, according to Clarence Thomas, the tribes aren't even sufficiently native enough to count anymore. Like,
oh my God. What was it that he said? That, like, that not a lot of them live on reservations? Like, where the fuck do you think they live, my guy? Like, what are you talking about?
What did Harlan Crow do to that man?
Oh my God.
It's like, it's worse. I don't know. It gets worse and worse and worse. And then, I mean, look, Alito's the grumpiest man maybe on the planet. He keeps winning
certainly on the bench
in these cases. And like, you can just, he's one of those writers where the sneer comes through the pages. Like, I read anything that Alito writes and it's just a sneer. He's like snarling through it. And he's snarling through the fact that this should just be a family law dispute. Like,
I mean, first of all, I'm going to go back and talk about how shady the Burkines are. If this is just a family law dispute, then there's really no reason for the Burkines to be in court because they were able to circumvent ICWA. They were able to adopt the baby that they wanted to adopt. The adoption went through 2 days. Something else I learned from Rebecca Nagle. I'm telling you, listen to this podcast, This Land. The adoption went through 2 days before Gibson, Dunn, and Crutcher swooped in and decided to file an appeal. And with that appeal, along with Texas and Indiana and Louisiana, essentially said, hey, can you just kill ICWA? Like, they were in family court asking that court to overturn a statute based on constitutional grounds. Why? Because Gibson, Dunn, and Crutcher has clients that are related, that are trying to get oil money, right? The Dakota Access Pipeline, that's Gibson, Dunn, and Crutcher.
Yeah.
So if you want to know why it is Gibson, Dunn decided pro bono to swoop in and help the Burkines, even though the Burkines had already won what they wanted, it was because it wasn't about the family law dispute, right? So no, Alito, it's not just a family law dispute.
No.
It's a dispute about tribal sovereignty and the ways in which there are conservatives who are trying to destroy it. And Gorsuch laid it out why that can't happen, right? And I think it's interesting that,
you know, that made him so mad. And I'm just imagining a family law dispute that has, you know, one side stacked to the tune of billing probably I don't know, $2,000-$3,000 an hour by the time you've got a couple of those attorneys stacked up, right? For one baby.
Yeah. Easy. Yeah. For a baby that was already adopted.
Okay. File it before Reed O'Connor, right? The original Maddie K.
The original Maddie K.
Okay. All right.
So what does the case mean, Jess? What are the big takeaways?
I mean, look, I'm having a hard kombucha because I was really thinking we were going to be talking about the separation of families here and having a very bad day, but we're not. Mm-hmm. What it means is that, look, ICWA remains the law of the land, along with its preferences for keeping children within tribal relationships during foster care and adoption proceedings. That's good. And Gorsuch's full-throated embrace defense of tribal sovereignty, I hope, has some staying power.
Yeah. Gorsuch is one complicated man.
Look,
I mean, great, because he gave us Bostock,
right?
Also, like, he comes out with these opinions, and you kind of want to remember when we hated him? Remember when he was the worst?
We called him Gorsuch
for like a full year.
We were very mean to that man. I mean, granted, he still had it coming to him, but
he had it coming.
We really gave him a hard time.
And now we've got like Justice Kegstand and Justice Nazi memorabilia, and it's like, it's too much. It's too much. So opinions are also happening tomorrow. Tomorrow's Friday, June the 16th.
Yes.
We are waiting on 303 creatives. We are waiting on Students for Fair Admissions versus Harvard. And we're also waiting on Moore versus Harper. That's that wacko independent state legislature.
That case, I just need to go away. Everybody we need that.
Jess doesn't even want to talk about it. She's just like, it doesn't exist.
I keep memory holding it, like, exercising some kind of editorial privilege and just refusing to talk about it. Nope. But we got to talk about it, folks. We will.
So, I mean, I'm hoping that they're going to gut affirmative action. Like, I know we said they were going to get ICWA, and I know we said they're going to gut the Voting Rights Act, and we were proven wrong on those two cases.
Happy to
They're
going
to gut affirmative action. They are going to. And I just hope they don't do it tomorrow, literally 3 days before Juneteenth.
So I will say,
let Black folks have Juneteenth.
If they do 3 days before Juneteenth, that is absolutely calculated, because these opinions don't just take like a day or two to write, right? They're not like banging out a draft over night like you and I would.
Like, we gotta get it done. Yeah,
they're going back and forth, sharing opinions, like, arguing. So these cases, while they are coming out in a trickle towards the end, they've been working on them for a while. So if that happens, then man,
it's purposeful.
That's purposeful, and we need to call that out. Oof.
And if it happens tomorrow, we will call that out on another live stream.
That's it. Thank you for joining us.
Thank you for joining us. Follow us on Twitter, Angry Black Lady Hegemony. Follow Rewire News Group, Twitter, Instagram. Sign up for our YouTube channel. And
it's amazing. We got one of these big cases that we've been covering the same week that we published our special issue on the Dobbs anniversary. 1 year later, we're creeping up on like one of the worst Supreme Court anniversaries that we will be marking from here on out at Rewire News Group. If you've not had a chance to check out that editorial package, please do. There is some really amazing work. Oh my gosh. Talk about a good way to mark a shitty day.
Yeah. Absolutely.
That's what I'll say about that.
All right. Well, that's going to wrap it up for us. What are we going to do, Jess?
We are going to see you on the tubes, folks.
We're going to shimmy and see you on the tubes.